All right. Good morning, everyone. My name's Hamish Geddes. I'm joined here with newly appointed Senior Associate Marianne Wen. Thank you, everyone, for joining us on this Wednesday morning to talk about security of payment and, in particular, all things in relation to payment schedules. We're hoping to go through this pretty quickly today. But please know that there's a Q&A available, or raise your hand if you want to have a chat. Happy to have it pretty interactive. But we'll be kicking off right now in relation to payment schedules. So previously we've gone through payment claims, but payment schedules are essentially the defence to any payment claim, and they are a critical document in relation claim is served. The respondent may reply to the claim by providing a payment schedule to the claimant, and it's got to state what you intend to pay and why, including if you're not intending to pay that full amount. So it's a critical document. It's certainly one of those documents that when you hear people say, oh, this is a legal document, it certainly is a document that in many cases becomes a crux of legal arguments. So the payment schedule is a key document to get right. And we hopefully by the end of today, you'll know exactly what you need to include in them. So over to you, Maz.
Sorry, just getting the slides. Thank you. So for timing and requirements, the particular provision that you need to refer to is Section 14 of the Act. And Section 14 of the Act stipulates that a payment schedule needs to be provided on the earlier of either 10 business days after receiving the payment claim, or within the timeframe set out in the contract. So if the contract says that the payment schedule needs to be provided within 5 business days, that is the earlier date, and you'll need to comply with that. Section 14 of the Act also outlines the essential requirements of a payment schedule. So briefly, payment schedule needs to be in writing. So if you've called up or responded to a payment claim, that wouldn't be a valid payment schedule. It has to be in writing, even if it's an email. You must identify the payment claim to which it relates. So if in a project would have multiple payment claims, in the payment schedule, if the payment claim is, for example, payment claim 10, the payment schedule should refer to payment claim 10, and the more detailed, the better. So if the payment claim was served on the 10th of October, you should say payment claim 10 served 10th of October. You'd also indicate what amount is payable. So this is called the schedule amount. Even if the amount is 0 or a nominal amount, you should still indicate what that amount is. So as silly as it seems, you'd still have to put $0. And the most important requirement is to indicate the reasons why you're withholding payment. So whether that is because there's offsets, or there's a delay, there's defects, or the scope of works have been deleted, you must indicate why the amount is being withheld. And the important thing is that you should always provide a payment schedule, even if you intend on paying 100% of the claimed amount, because there is significant implications for not providing a payment schedule. So I'm going to move on now to timing is off. Is there anything else you'd like to add to this slide, Hamish?
No, I mean, the essential requirement, well, I guess a little bit, yes, just to expand a little bit on that last point. In relation to always providing a payment schedule, our advice to our clients is often have the payment schedule as part of your payment workflow. And what that means is, even in circumstances where you intend on paying 100% of the claim, issue a payment schedule that says you're going to be paying 100% of that claim. That's the easiest way to ensure that process, if you ever come to a point of disputing the amount that is claimed, is followed. So having the people in your accounts team knowing that when they get an invoice, they respond with a payment schedule that says invoice 10, dated 10th of October, amount claimed $10,000, amount paid $10,000, There doesn't need to be any reason or anything like that. It's a great system to implement within your businesses to ensure that in circumstances where you're not agreeing to that full amount of payment, it's just an organic thing. Like it comes through, here's an invoice, that invoice seems weird, or that's more than it's claimed, or that's more than I want to pay because there's set-offs or something. It's already there in the mechanism to do it. So yeah, that's really critical. It's also critical not only in the security of payment process, but it's also critical in circumstances where a claimant might have multiple invoices or projects, multiple invoices across a various amounts of projects. If you don't have a document that says, I'm paying you that $10,000 for the payment claim dated 10th of October on job X, if there's a dispute on job Y, and then that has to go to court, and you have paid certain amount of money but haven't paid other money, and you're just paying it to the claimant, they can essentially distribute and put that the amount that they receive to any invoice that they have outstanding in relation to the relationship between you and the claimant. So the payment schedule is just a great check for businesses to ensure that they're paying the invoice that they say they're paying for the amount that they say they're going to pay, and it's just a great legal document that, in my view, is a business critical document for everyone in the construction industry.
Thanks, Hamish. So the next slide is that we'll be discussing what happens if the timing is off. So this is instances where you have failed to provide a payment schedule within the stipulated timeframe or at all. So like I said earlier, it does have significant implications. The respondent then becomes liable for the whole claimed amount. So regardless of whether you have a defence or reasons why payment was withheld, the fact that you haven't provided it on time or at all, automatically you will be liable for that amount. So as the claimant, there are three options available. So under Section 15 of the Act, you're entitled to enforce the claimed amount as a debt due and payable in court. So what that is a summary judgment proceedings. Usually this is through filing a notice of motion in court. So the respondent will not be entitled to raise any defence or cross-claim. So the only thing that the claimant has to establish in this case is that they served a valid payment schedule served a valid payment claim, and a payment schedule was not served at all or in time. The second option would be to make an adjudication application. If in the instance a payment schedule wasn't served, you have to the claimant will have to serve a Section 17.2 notice. So a Section 17.2 notice, as the name suggests, is under Section 17, subsection 2 of the Act. You have to serve a notice to the respondent to give them the opportunity to serve a payment schedule. So the time frame is 5 business days after you have served that notice. That means the respondent will now have a new time that they need to comply with and respondent has time to comply and serve another payment schedule, so a payment schedule within that time frame. If they fail to serve a payment schedule, you then be entitled to adjudicate on that payment claim. The other option is, another option for the claimant is to serve a notice of intention to suspend works. So in this case, it's under Section 15, subsection 2B and Section 27 of the Act. As the claimant, you will be entitled to serve a notice of intention to suspend works. This is similar to the Section 17.2 notice, but it's in relation to suspending of the works. This then provides the respondent with 2 business days to rectify, or in most instances to pay the amount claimed. If they fail to undertake those actions within that time frame, 2 business days has lapsed, you'll be entitled to suspend works. So again, that would have significant implications to your project if works are suspended. Hamish, is there anything else that you'd like to add to this slide?
Just in relation to the enforcement as a debt due and payable in court, we've touched here in relation to payment schedules, but the people that actually need to respond and provide a payment schedule, in certain circumstances, that's not always the head contractor or otherwise, is it? If you receive a payment claim that you don't think you're liable to pay, should you be issuing a payment schedule?
Sorry.
If you're in circumstances where you've received a payment claim that you don't say you're liable to pay, say, for example, someone's giving you a payment claim on a job that you're not the head contractor on, for example, should you still be issuing a payment schedule?
Yes. So in any instance that you think that there is reasons for withholding payment, you should still issue a payment schedule just to cover your bases.
Absolutely. It is such a critical point, and if it is in your process already to issue a payment schedule, if subcontractor X gives you an invoice for a project that you're not the head contractor on, you've got nothing to do with it, you want to be able to issue a payment schedule that says, I don't know what this is for, I'm paying you zero because we're not the head contractor on that job. At least you can have that. That's an easy argument to have in an adjudication or something along those lines, far easier than that person, you not issuing a payment schedule, and that claimant trotting off to court and getting a judgment against you. So, critical document.
So we will be touching on adjudication processes next week, but very briefly, if you have not submitted a valid payment schedule and the claimant elects to go to adjudication, you're only you won't be entitled to submit an adjudication response. Another point that I didn't touch up on in the previous slide is that if the respondent has failed to issue a payment schedule or at all or within the time frame, you only be entitled to elect to either go to summary judgment or adjudication. You won't be entitled to do both.
And so if you have to go to adjudication, you have to follow that 17.2 notice process, don't you?
Yeah. Yeah. So we have touched on that previously. Again, with that, you will need to issue a section 17.2 notice to be entitled to go through that adjudication process. Back to you, Hamish.
Look, we've already touched on it, but again, just to ramp this home, the payment schedule is the most critical process in this SOP process. It's a document that certainly, when you hear people thrown around, it's a legal document. It certainly is. It is the document that is argued about the most in adjudications and at court as to whether it is valid, and it's a critical document to get right. Luckily, it's a document that if you have it in your workflow, it's going to all work out for you. And most of the payment schedules that you provide are going to be valid. Particularly in circumstances, my view is that you should always be providing a payment schedule, but particularly provide a payment schedule where you believe, no money is owed or less money that is claimed is owed to the claimant. You believe the payment claim is not valid. So putting in a payment schedule that says the payment claim is not valid is just as critical in circumstances where you believe the payment claim is not valid. For example, they may have served the payment claim outside of the contractual process or outside of outside of the Act, or depending on when it was, whether they had a valid reference date. Whatever it is, it's definitely better to put as many reasons for why you're not paying and why the payment claim is not valid to within the payment schedule. Or as we've touched on previously, you believe you've got no contract with the claimant, and so that's just a really critical element. And if you want to see what you should include in relation to payment schedules, the case there, Brookhollow and RR Consultants, is a great one to read up on. Yeah, so look, really include all the reasons for withholding payment. This is under section 22B 22B of the Act, and means that you have to provide all reasons for withholding payment. Now, the basis of this is that the security of payment process is a process that should allow contractors and subcontractors to be paid. In circumstances where that is the case, the legislature wants the parties to have a full understanding of what is being claimed and why the amount being claimed is not being paid. They don't want it to be vague or uncertain in any sort of terms. They want to make it clear, we're not paying you because of X. And you need to make sure that whatever X is within your payment schedule. And here are just some of the reasons why you may not be paying or you're putting a payment schedule in. where you're not agreeing to pay the full amount. So, for example, there's no construction contract. The contract or works are excluded under the Act. So mining in particular, the payment claim's not valid, as we've touched on previously. Look, served outside of 12 months of the work being carried out is something that certainly has been a trigger in matters that we've acted on, and something that is parties need to be very, very aware of and very careful of. But it is, again, if you receive a payment claim that is outside the period that you think is valid, you should still put a payment schedule in that says it's outside, it's not valid for these reasons. Do not just simply ignore it, because that will set off a whole new process, particularly if they go under 17.2, but you want the ability to raise a defence. And then, of course, all your substantive and contractual reasons. So, yeah, the works aren't performed, they're not completed, they haven't reached the milestone where payment arises to be due. There's no contractual entitlement. They're claiming variations, EOT delays, or liquidated damages, etc., for things that you say are not valid. But you need to be putting those in there and making it really clear of why you are not going to be paying those amounts, or you're withholding other money because of a set off or for defects or termination rights, etc. So whatever it is, and these are just examples of numerous things, and you do need to refer back to obviously the contract that you have. There should be any reasons for why you're not paying the claimed amount or the full claimed amount, really need to be included in this payment schedule.
So Hamish has already reiterated the importance of having it quite detailed, but you need to be very clear and specific for the reasons of withholding payment. So we will be talking on some case authorities that will describe a bit more on these reasons, but the details should be sufficiently clear to describe the dispute. And of course, the reasons for withholding payment will vary case by case, and will depend upon your project that you're working on, or the job that you're on. So that when you issue a payment schedule and you have the reasons for withholding payment, the claimant should be able to pick up the payment schedule and understand why you're withholding payment and whether they should pursue their claim to adjudication. So, whether it's a delay or an offset or something specific to your site or project, you should be very detailed and clear and explain why you're withholding that payment. So you can use abbreviated descriptions or reference, but only if they're readily understood by the parties. So an example is if you've previously or always abbreviated and referred to a particular job or particular contractors abbreviated, use those abbreviations if you'll be able to show in prior correspondence that you've always referred to, job as job 1 or job 2. In instances, we probably should steer clear from abbreviations if you can. We understand that payment schedules and payment claims will need to be done quickly, but you can use abbreviations, but if you can help it, probably don't. So you can incorporate other documents by reference. I will be touching on this in the case authority in a minute. But if you are going to incorporate documents, make sure that they're clearly identifiable and that the claimant will be able to know what exactly you're incorporating in the payment claim. So again, the example that I had previously, if the particular payment claim that you're referring to is payment claim 1, then in your payment schedule, you should be referring to that. A good example we have for withholding payment is if you've been issued a payment claim and those works have already previously been claimed, and you've responded that in a previous payment schedule. In this payment schedule, you should be referring to, on this date, I was issued a payment claim in this amount, it claimed for the scope of works. I've already referred and responded to this particular scope of works in payment schedule dated 10th of October. So that would be sufficient for someone to understand what documents are being incorporated by reference. And the last point is that you don't have cryptic or vague reasons for withholding payment. So for example, saying, as discussed, that would be too vague. You wouldn't understand particularly the reasons why for withholding payment. And if you are referring to a discussion or a particular document or a meeting where there could potentially be file notes, refer to that, be quite specific on why you're withholding payment. So I'll be touching up on some case authority now. So the first case is Stahl and Timber. This is a New South Wales Court of Appeal case in 2019. In this particular case, Stahl and Timber engaged a subcontractor to perform some floor grinding in various sites in Sydney. A dispute arose between the parties in relation to the quality of work. So I'm just using round figures up for this example. So a payment claim was issued roughly around $106,000. Payment schedule, Stahl and Timber responded by email. It says, if you want, make an appointment with me, come to my office. I will show you the working agreement between Stahl Timber and RK Grinding. Many emails, photographs, videos, back charges from builders and other trades, complaints from my client. You will understand why I can't pay you. The damage you've done is more than what you've claimed. So in this case, the subcontractor filed a statement of claim and a notice of motion seeking summary judgment on the basis that that email was not a valid payment schedule. So the court ruled that did award summary judgment, and Stahl and Timber appealed this case. The Court of Appeal upheld the decision and said that that email was not a valid payment schedule. So in the reasons for why it wasn't was that nothing in the email indicated for a particular invoice or project. This subcontractor was actually engaged in 5 various sites. There's no reference to a particular invoice, which multiple invoices were issued, or to any one of the 5 projects. Based on what was said in that email, it wasn't sufficient for the claimant to understand what was actually in dispute. Even though there was reference to multiple emails and photographs and videos, none of those were actually enclosed or with any sort of particularity that the claimant would be able to understand what particular documents that they were referring to. In this particular case, the Court of Appeal did reinforce that even if there is no payment to be made, you still need to be clear on why, for the reasons of withholding payment. And again, if you are going to incorporate documents, it must be sufficiently clear to the person reading the payment schedule what documents are being incorporated. Is there anything you'd like to add for this particular case, Hamish?
No, you covered it off excellently. Thank you.
So the next case is Multiplex. So in this particular case, Multiplex was a head contractor and they engaged Leahy as a subby to assist in a large construction project in Sydney. Again, I'm using round-up figures here, but the subcontractor issued a payment claim in the amount of $708,000. Multiplex issued a payment schedule in time, and the dispute went to adjudication. The adjudicator awarded the subcontractor the amount of $582,000 on the basis that the reasons for withholding payment in the payment schedule wasn't established. So in the payment schedule, Multiplex said back charges, contract changes, scope deletion, in reference to a particular document. The document was attached to the payment schedule and had the same heading. It said BC 1 deletion of sale and tenancy with panels by others and related deduction of $434,000 and $10. So in this particular case, the parties agreed in 2002 that a particular part of the scope of works would be removed. And the basis for that was because there was a delay by the subcontractor, and that amount of engaging another contractor and the costs associated would be offset from Leahy. So in this particular case, the Supreme Court held that payment schedules and payment claims are given and received quite quickly. And in instances where parties are engaged in a large construction project, they're both highly experienced parties in the building construction industries. They understand the history of the project and understand the broad issues of the dispute that arise in the payment claim. And ideally, the reasons will need to be clear for a dispute. So the Court of Appeal upheld that decision that that was a valid payment schedule in these instances, and the reasons for withholding payment was valid.
Yeah, I think that's a really good example. It sort of contradicts a little bit with what we were saying in the second one, but in the first case. but parties need to realise that the best way to respond with a payment schedule is to make it as clear as possible. Now, that's not to say that you do need to include absolutely everything, and that's what the court found here, that the parties understood. When Lay didn't get that $434,000, they knew that the reason was because in BC1, back charge 1, the deletion of Southern Tennessee's wall panels, it's easily referred to, and that's a reasonable thing to understand. However, it still can be easier, and you won't get into these problems where you articulate this a little bit better. And one of those key things is, while you have your payment schedule within an invoice workflow, what is critical is that you will most likely understand where a claimant is likely to have a dispute in relation to a payment claim. It's fairly unusual that our clients come to us and they say, "Oh, I had no idea that this was ever going to go down this path." They usually do, and in those circumstances, while it should be already in your workflow that it is a fulsome payment schedule, certainly bulk it up so you can't have any of these arguments, because these arguments, obviously, you have to go to court and incur all the costs of lawyers, etc. If you make it really clear, and that may have been just cut and pasting BC1 to BC16 straight in the bottom of the reasons, then most likely the adjudicator would have understood exactly what that meant, and did not award that amount to Lay, which required the multiplex to trot off to the Supreme Court to get it over.
Yep.
Returned. Stopped there. All right, serving a payment schedule. So this is the last key point, is once you've actually got a fulsome payment schedule drafted, make sure that the person actually gets it. That's the last key point. Section 31 of the Act governs how that is to be done. So should your contracts, but make sure that you follow up with the normal processes. If you are in a dispute, obviously you do not need to do this for absolutely every single payment schedule, but certainly those ones that may be a bit of a red flag, make sure they are done in these circumstances. I've certainly been trotting around town with hard copy payment schedules and reasons in my in my bag, and dropping it off at person's places of business at 4:30 on a Friday afternoon to make sure that the payment schedule was actually served. So you need to make sure that occurs, so that and that would be in the circumstances where the payment claim hasn't been responded to in the 10 days, and the claimant's heading off to going at summary judgment, or the 17.2 notice hasn't been complied with. But make sure that the fulsome payment schedule is provided to the claimant. And that's service. Next slide, thanks, Mez. Yeah, so look, these are the key points. Make sure it's clear, make sure it's accurate. If it's a red flag payment claim, make sure that you are being as fulsome as possible in relation to everything. Make sure that you are complying with the timing requirements, make sure it is sent, and make sure that if you take anything from this, work out how you can get this into your workflow with your accounts team or people on site in particular, your PMs and things like that. Make sure that they are aware that if an invoice comes through that looks a bit weird or unusual, it does get into that process and it's responded to in kind. So a little bit of training on exactly what those payment schedules are can avoid some very costly mistakes. Even if you end up being correct, you still need to go through a fairly long, arduous process in relation to whether that's summary judgment or overturning an adjudication. So it's something that can be avoided pretty easily, but it's about making sure that you've got it in the process and you're giving a fulsome and clear payment schedules to the claimant. So look, that's it for today. If there are any questions, just feel free to type them into the Q&A, and Marianne and I will respond. Otherwise, the slides will be provided to you by email shortly. Of course, always reach out if there are any questions. I recommend that you sign up to our newsletter as well, so you can get some up-to-date commentary and things that are happening in particular in the construction industry. So, but yeah, if there are any questions coming, and have a great Wednesday.
Thank you.
Yeah, of course. Don't forget, 11 a.m. next week, Marianne and Mike are talking about all things adjudication. So you've submitted that nice fulsome payment schedule, and the claimant doesn't agree, and you're off to the next step. So yeah, that one's surely one not to be missed. Thanks, everyone.
Thank you.